Good evening, America. This is Jeff Desk. We open our broadcast tonight with a rapidly evolving and deeply significant development that sits at the crossroads of justice, authority, and the highest office in the land. Fresh reports and court documents are prompting urgent questions this evening. Are federal marshals gearing up to remove former President Donald Trump from his Mar-a-Lago residence as the property stands at risk of being seized due to outstanding court-ordered payments? Let me state this plainly. We are dealing with fast-breaking details, and right now, there is no official confirmation from authorities. Yet, if these reports prove accurate, the consequences would stand as entirely unique in contemporary American history. At this point, people with knowledge of the current enforcement efforts linked to both criminal and civil cases indicate that federal officials possess the legal authority to proceed with taking control of assets when required payments from court rulings go unmet. Mar-a-Lago, the Florida residence of the former president, a key symbol of his political movement and his primary base of operations, has often been called by Trump the most valuable part of his entire portfolio. This evening, that prized possession appears to face a genuine legal challenge. Let's examine the responsibilities of the United States Marshals Service. When a court concludes that required payments or obligations remain unfulfilled, the Marshals serve as the official enforcers. Their function carries no partisan element. It is purely administrative. They carry out judicial directives, which can involve taking possession of property, carrying out removals, or protecting government interests. If an order of that kind is handed down, the marshals must proceed without regard for who is involved. That impartiality is precisely what makes the current situation so remarkable. Special Counsel Jack Smith and the mounting legal demands. The ongoing work of Special Counsel Jack Smith keeps building substantial pressure on matters related to the former president's financial affairs, handling of sensitive materials, and actions after leaving office. Experts in the law make it clear that this situation stems not from partisan aims, but from the necessity of following judicial decisions. Even so, representatives for the former president have strongly rejected suggestions that Mar-a-Lago faces any immediate risk, describing those accounts as guesswork and inaccurate. Why does this hold such importance? On the international stage, the sight of federal agents compelling a former American president to leave his personal property would represent an event without precedent, creating powerful repercussions throughout U.S. politics and far beyond our borders. Those who back him would view it as targeted mistreatment. Those who oppose him would regard it as the system working as intended. The judiciary would regard it as simply upholding its own decisions. As we stand tonight, no verified removal has taken place during this program. No official notice of asset takeover has appeared publicly. Details in court papers and timelines for enforcement continue to be protected or contested. Nevertheless, the core issues can no longer be avoided. When legal standards extend to the most influential individuals, does this represent the greatest examination of our democratic principles or the beginning of its most turbulent period? What occurs when legal authority finally arrives at the door without seeking approval? Have federal marshals received the green light to step in? When a United States court delivers a binding directive, one organization holds the duty of ensuring that directive moves from paper to action. That organization is the United States Marshals Service, and its powers are both straightforward and far-reaching. The initial major point in this unfolding account is straightforward yet striking. Federal marshals hold the authority to carry out court directives. There are no carve-outs, no ceremonial protections, no partisan barriers. The Marshal Service ranks as the nation's longest established federal law enforcement body. Their mission involves no discussion. It involves carrying out orders. Once a judge approves a command, whether for detention, property takeover, removal, or management of assets, the marshals represent the final link connecting the bench to actual results. This power draws not from public attention, but from statutes passed by Congress. When a court finds that a required payment or obligation stands unsatisfied, whether financial or otherwise, the marshals receive clear legal permission to intervene. They may protect real estate, escort individuals from premises, halt or redirect holdings, all under explicit approval from the bench. Here, the narrative shifts from partisan debate to concrete legal outcome. Marshals do not select who they pursue. They do not cast ballots. They do not run campaigns. They move solely when instructed by the judiciary. For that reason, even the prospect of their participation indicates that a matter has advanced to the stage of actual implementation, where postponements end and adherence becomes mandatory. In situations involving unsettled financial rulings, the procedure remains careful yet relentless. After all appeals conclude or time limits pass without action, a judge may approve measures to recover what is owed. At that stage, marshals receive the call not to discuss terms, but to implement the ruling. Importantly, national statutes draw no lines according to position, whether involving ex-officials, wealthy executives, elected leaders, or ordinary people. The power remains identical, the instruction remains identical, the authority remains identical. That explains the significance of this point. If federal marshals have become engaged or stand prepared to engage, it signifies that the justice system has progressed past discussion. A judge's decision no longer serves as a caution, it stands as an instruction. And that prompts the central, compelling issue of this hour. When judicial authority speaks and enforcement stands prepared, who, if anyone, remains out of reach? This concerns not partisanship, but implementation. In our nation's framework, implementation marks the point where statutes gain true force. What if the entrance to Mar-a-Lago ceased to represent dominance and instead became a focus of judicial action? Could the country's most recognized private property actually change hands? The second major point driving this account forward stands blunt and troubling. Mar-a-Lago stands at risk of seizure because of unsatisfied court judgments. That does not indicate any seizure has taken place. It indicates that statutes permit it when specific requirements align. And that difference carries enormous weight. According to American statutes, when a court establishes a monetary obligation and that obligation remains unmet after designated periods, the court holds the power to approve recovery steps. Those steps may involve placing claims, mandating sales, or, in rare circumstances, taking control of physical real estate. Mar-a-Lago serves not merely as a residence, it functions as an exclusive membership facility, a platform for political activity, a recognizable brand, and a highly valuable holding. That very value places it squarely within discussions of enforcement. When judges seek to resolve unpaid obligations, they focus not on symbolic meaning, but on tangible worth, ownership details, and whether an asset falls legally within reach for attachment, claim, or oversight. Should a holding belong to a person or organization listed in a ruling, and should safeguards through appeals end unsuccessfully, that holding enters the realm where enforcement applies. This constitutes not retribution, but recovery. Specialists in the field emphasize that taking possession never begins as the initial move. It arrives as the final option. Earlier stages generally permit arrangements for payment, posting security, or disposing of other holdings. But when those avenues close, the law continues forward. That reality explains why even raising the idea of Mar-a-Lago in enforcement language proves so unsettling. For many years, the estate has stood for protection, privilege, and sway. Today, it appears in the same terms applied to any other substantial asset facing a court directive. Those who support the former president maintain that such a step would cross an unacceptable boundary. Those who criticize him insist the opposite, that true legal equality leaves no holding immune. Courts, though, engage in no debate. They assess facts. Does a legitimate obligation exist? Has it been met? Do grounds for action stand? When those elements align, authority proceeds. Significantly, the potential for seizure does not automatically translate to immediate physical takeover or full restriction. It may commence with claims, limitations, or judicially supervised management. Even those initial measures, however, would mark a profound change, from a center of political strength to an object of legal obligation. That explains the force of this point. Mar-a-Lago consists of more than structure and grounds. It embodies an idea, a representation, a platform. Should that platform ever come under judicial oversight, the signal would reach well past Florida, speaking volumes about responsibility, influence, and the boundaries of individual influence within a system ruled by law. So the pressing issue endures. When a judge weighs a decision against a luxurious coastal property, do representations retain importance, or does legal authority deliver the final word? That is why attention from around the globe remains fixed. What unfolds when pressure mounts from multiple directions simultaneously? Is Special Counsel Jack Smith increasing the strain to a critical level? The third major point propelling this narrative forward stands evident and weighty. The work of Special Counsel Jack Smith heightens legal demands. This extends beyond a solitary matter. It involves a coordinated effort by a specially designated investigator. Jack Smith received appointment with a focused yet potent assignment to examine issues of national significance free from partisan influence. His team operates discreetly, systematically, and with a single purpose: constructing cases capable of surviving the most rigorous judicial review. That careful method accounts for why observers now characterize the legal strain as growing stronger. Smith's inquiries proceed along several simultaneous paths: potential criminal liability, procedural schedules, monetary duties, and adherence obligations. Each path may appear distinct, yet collectively they create mounting constraint with every submission, every decision, every rejected request. Experts in legal matters highlight a key insight. Strain emerges not solely from final outcomes. Frequently, it arises from the procedures themselves. Court appearances consume time, legal requests consume funds, appeals often require financial guarantees, rulings impose payments. When various matters progress concurrently, the framework itself generates the force. The special counsel does not handle property seizure or payment collection. That responsibility belongs to courts and enforcement personnel. His assignment involves pursuing accountability wherever evidence directs. Yet the outcomes of those pursuits can extend into every aspect of an individual's existence: monetary, political, personal. That explains why the term intensify carries such weight. As inquiries advance from examination to formal charges to courtroom preparations, expenses increase in both concrete and broader terms. Tactics once used to extend timelines now encounter firmer judicial boundaries. Schedules tighten, choices diminish. Meanwhile, civil obligations, fines, and securities continue without interruption even during related criminal proceedings. This creates a cumulative impact. Those who support the former president describe Smith's methods as excessive, a prosecutor stretching authority too far. They perceive partisan intent. They perceive selective focus. Those who criticize him see a different picture, a special investigator fulfilling the precise requirements of the position, pursuing facts, disregarding position, allowing courts to determine results. What remains beyond dispute is the reality of the pressure. Every submission generates a required response time. Every decision generates consequences. Every setback generates financial and legal responsibilities. When those responsibilities accumulate, enforcement grows unavoidable. That process illustrates how inquiries, even absent a conclusive judgment, can fundamentally alter circumstances. They alter assessments of risk. They alter balances of influence. They alter calculations of feasibility and endurance. Jack Smith requires no public statements to exert force. The court calendar accomplishes that task. And that directs us to the central, compelling issue within this point. When multiple inquiries expand, schedules intersect, and courts cease granting extensions, does influence continue to provide protection, or does the procedure itself become inevitable? That explains why each fresh submission holds significance. That explains the rising strain. And that explains why the world remains focused on what develops next. What if the record of this era is being shaped at this very moment, with no possibility of halting progress? Has the nation arrived at a juncture for which it never planned? The fourth major point in this compelling account strikes directly at why the present feels so profoundly disturbing. Actions without parallel directed toward a former American president. This stands far from ordinary. This stands far from expected, and that very distinction explains its importance. Never in recent American experience has a former president confronted legal challenges of this magnitude, all at once in full public view, with genuine enforcement possibilities on the horizon. Inquiries, formal accusations, financial obligations, and potential implementation measures have converged at one extraordinary juncture. The nation was established on the principle that no individual stands above legal standards. Yet it also developed around informal understandings and customs that historically insulated former presidents from overt encounters with the justice system. Those customs now meet reality head-on. This point extends beyond any single matter. It concerns a boundary never previously crossed. When an ex-commander-in-chief becomes subject to the identical processes applied to any other individual, demands for information, financial securities, obligations, and potential enforcement actions, the entire structure steps into unknown territory. Scholars of law describe this as a rigorous examination of democratic foundations. Those who support the former president perceive risk. They contend that opening the path to legal pursuit and enforcement against a past leader could enable future leaders to wield the justice system as an instrument of power. To them, this constitutes not responsibility, but escalation. Those who oppose him perceive the reverse. They contend that declining to proceed would establish a permanent exemption, creating practical immunity for anyone who once occupied the presidency. To them, this constitutes not vengeance, but legal equality at last. Courts, however, speak not in abstractions, but in directives. And directives, once issued, require execution. That reality transforms the unprecedented into the practical. Every judge understands that their decisions will undergo examination for generations. Every prosecutor understands that history observes closely. Every enforcement body understands that a single error could send tremors through the political landscape. No guidebook exists for this period. Only statutes applied in the present under worldwide attention. All of this unfolds while the former president continues as a major political presence, a contender, and a leading voice in public discussion. That single fact greatly amplifies the significance of every court submission, every decision, every deadline. That explains why financial markets observe. That explains why international partners observe. That explains why opponents observe. Because the manner in which the United States manages this period transmits a message well beyond its boundaries, concerning whether influence offers permanent protection or whether institutions endure even under extreme strain. History grants no pause for reassurance. It advances through choices. And that brings us to the question that lingers across this entire point. When legal standards reach a former president in plain sight of the globe for the first time, does this demonstrate that democratic principles endure or serve as a signal that those principles face severe strain? That explains why this period stands without parallel and why retreat has become impossible. What if a single legal matter within the United States generates tremors throughout the entire world? Are we witnessing a democratic upheaval as it unfolds? The fifth and concluding major point carries this account well past courtrooms and private estates: the international political and democratic consequences. This no longer qualifies solely as a domestic matter. When the United States, the planet's most influential democracy, encounters a scenario in which a former president faces determined legal enforcement, the effects extend outward. Partners, rivals, financial systems, and movements worldwide follow every development closely. Why? Because events here reshape expectations globally. For generations, the United States has presented itself as the leading example of democratic standards, legal equality, and institutional steadiness. American elections, judicial processes, and peaceful transfers of authority have served as models, even as lessons for other countries. Now, the international community poses a difficult question. Can those institutions withstand pressure when the issues reach this level of importance? Across Europe, experts in law discuss historical comparisons. If the United States can hold a past leader to legal account, does that reinforce democratic foundations or create a pattern of partisan legal actions? The response remains uncertain, and that uncertainty carries real weight. In nations with centralized control, official media already frame the narrative. Some portray this period as evidence that democracy breeds disorder, that even the United States suffers instability, division, and susceptibility to internal struggle. Others employ it to defend their own restrictive measures, asserting that even America takes similar steps. Simultaneously, advocates for open governance worldwide perceive a contrasting message. To them, this provides proof that no individual stands beyond reach, that even those who once wielded immense power can face consequences under law. For those efforts, the signal proves inspiring. This creates a striking contradiction. The identical development can serve to challenge democratic systems or to uphold them. International financial markets register the impact as well. Stability within the United States transcends theoretical concern. It influences currencies, capital flows, security partnerships, and resource costs. When news suggests potential instability, enforcement measures, or strain on constitutional frameworks, markets respond without delay. Diplomatic representatives quietly evaluate possibilities. What unfolds if legal demands intersect with an electoral contest? What unfolds if judicial directives collide with political activity? Those questions arise not only in Washington, but in European capitals, in Beijing, in Moscow, and elsewhere. Then consider the battle over information. Online platforms, government communications, and worldwide news outlets all promote varying interpretations of the same events. One perspective labels it responsibility, another labels it mistreatment. The reality, as ever, undergoes contest in the present moment. That explains why this fifth point may hold the greatest significance of all. Democracy consists of more than statutes. It consists of shared understanding, a conviction that rules apply evenly and that systems can endure strain. Should the United States manage this period with openness, moderation, and institutional strength, it could emerge more resilient, a reaffirmation of democratic endurance. Should it falter, should disorder, disruption, or partisan reprisal shape the result, the consequences will extend far beyond American shores. And that directs us to the final, inescapable question. When the foremost democracy on earth subjects its core principles to the most demanding trial, will it establish a worldwide benchmark for responsibility or serve as a warning example for other nations? The response will influence international affairs for years to come. This is Jeff Desk. Stay awake, America. We'll see you in the next one.